Okay, in this section, we're going to talk about negligence, and this is on page 59. And as you can see at the very top, this is also a 100%er. I ask this every time. What are the four basic elements of negligence? Duty, breach of duty, injury, causation. So the reason I ask this question every time is negligence is probably the most common reason why somebody that doesn't know somebody else, or even if they do know them, the most common type of a lawsuit in civil court. Now, it might be breach of contract or negligence are probably about equal, but I would say negligence is probably most common. So the reason why I say that is negligence is what applies when there's an automobile accident or other type of injury that is caused on an unintentional basis. So the first thing I want you to know about negligence is the whole idea of negligence is you have an obligation or a responsibility or what we call a duty, which is the first element. You have a level of responsibility that you must adhere to, and if you cause somebody harm, either bodily harm, physical injury, damage to personal property, damage to somebody's reputation or their business, or some type of, when I use the word injury, it could be personal injury or property damage. If you were not acting in accordance with your legally mandated duty, level of care, responsibility, which we'll get into more in a minute, then you are responsible to pay for the injuries and damage that you cause, even though you did not intend to cause the harm. So negligence is basically an unintentional tort. It is the idea that even if you did not mean to cause an injury or harm, if you cause that injury as a result of your breach of responsibility, you will still be responsible, liable to compensate whoever you harmed for whatever damages you've caused, even if it was accidental, so to speak. So this is where, again, negligence is the most common type of a tort in the real world, because this is where we see automobile accidents, or at work, or like if you have a restaurant and you fail to cook the food to a high enough degree and somebody gets sick as a result of food poisoning. That's, you didn't really mean to do that, but you weren't following your duty of care. And so therefore you are responsible to pay for those damages. So the idea of negligence is based on this sort of amorphous or general idea of responsibility, that if you violate it, you will be responsible for whatever harm may flow that is foreseeable from that breach of care. So there are four elements: duty, breach or violation of that duty that causes harm, an injury, and causation. That is, what happened has a direct link with the harm that you caused. Now, these four elements are very important because all four of these elements must be present in order for there to be negligence. You must be able to prove that all four of these elements link up with each other. If you don't have one of the elements, then there is no negligence. So the idea is there's a duty. You have to establish, if I'm suing somebody for negligence, I have to establish what was their level of responsibility that they owed. Part two is, did they follow or live up to that level of duty, that level of care, or that level of responsibility? And as a result of not meeting that standard, did they cause an injury? Was that injury related directly to the duty? So you must have all four. Now, the reason why I'm kind of harping on this is I will ask you a test question, and I'm going to ask you, was this person negligent or likely negligent? And when you're analyzing that, I want you to look at all four elements, because if there's any one of them that's missing, or if they don't link up with each other, then there is no negligence. Okay? And I'll show you some examples or talk about that more in a minute. All right, so let's take a look at the first element of negligence, and that is duty, otherwise known as responsibility, otherwise known as standard, or whatever word you want to use. It's basically, what is your responsibility level? How should you be behaving? What is your level of responsibility in a given circumstance? So next page over, I have listed out various different terms that we use when we describe what we mean by a duty. And these are not necessarily in any sort of order, but at the very top we have put the most basic level. So to begin at the top with the reasonable person test, right here. The reasonable person is a fictitious person that we use in law, also in economics they talk about it. And that is the idea of, okay, what is a fictitious person? What does it mean to be reasonable? And the basic idea is, in all aspects of everything you do, were you acting in a way that the average reasonable fictitious person would have acted? Were you being reasonable under the circumstances that existed at the time? And this is not really a well-defined standard. It's really a subjective standard in many ways, and what I mean by that is it will depend on the circumstances. It will depend on, maybe the weather, what time of day it was, what resources were available at the time, was it an emergency situation? So it's a generalized standard, and it's intended to be very broad in nature, or in scope. It's not necessarily going to be written out specifically what you're supposed to do. And so this can be sometimes kind of hard to understand, because essentially this creates this generalized level of obligation or duty, and you may not know what the standard is. It's basically what the jury and the judge decides in the lawsuit based upon what happened. There may not be a specific law that tells you what you're supposed to do, either because it's a new novel situation or a technological issue that's new or some other novelty, or maybe it's just something that's never occurred before and there's never been a precedence to rely upon. So at the very basic level of all things that we do, sitting here in the classroom today, you all have, as do I, an obligation to act in the way that a reasonable person would under the circumstances. And again, this may change. So, for example, driving. This is where we see the basic idea. It's called the basic rule, which is written into law, that everybody has an obligation to drive in a reasonable manner, depending on the circumstances that exist at the time. And that may be a situation where, based on the circumstances, it's unreasonable to go the speed limit, for example. Speed limit sets a standard, maybe it's 55 miles an hour, but if there's 2 feet of snow and ice on the ground, and there's cars all over the place that are stalled, it's probably not reasonable to go 55 miles an hour. Or if there's a bunch of pedestrians in the area, even though it's a 30-mile-an-hour zone, you've got a lot of pedestrians, and going that fast, even though you're within the speed limit, is not reasonable. So the idea of reasonability is this general, what would the fictitious reasonable person do under those circumstances? And if you didn't act in that way, even if you were going the speed limit, but if it was unreasonable, you're still negligent. You still violated your duty. So again, this is sort of the basic foundational idea of duty. And so if there's no other duty that applies that's more specific, then the reasonable person test will apply. And that will be essentially up to a judge and a jury to make a determination in a trial based on the facts of that case. So that's the basic level of care. It's like the default level, if you would want to put it in that terms. All right. So next, let's go to number 2, and this is probably more common, and this is the idea of a duty established by law. That is, there is a rule of law, either a statute or an administrative rules, where we find a lot of these, that gives you or tells you what your obligation or requirement is for that activity. So for example, if I have a restaurant, there are administrative rules on how hot you have to cook food, how you have to store food, what, temperature-wise, how long you can keep food uncovered, and all those kind of things. We have mechanical standards. So electrical standards like electrical code and building code and plumbing code. We have, in the automobile and vehicles, we have a number of standards that must be met, safety standards, especially in commercial vehicles. How much tread do you have to have on your tire? How thick do your brake pads have to be? Other standards are speed limits and traffic rules. That is, you have to signal during a lane change. You have to maintain an adequate lookout to make sure you don't run over somebody or get into a collision. You have to turn your lights on at nighttime, and sometimes during the day if it's adverse weather. Following too close. All of those kind of traffic laws establish a duty. And so the idea of negligence per se means in and of itself, of its own self, automatically, in another way of looking at it. So this is a basic idea that if the law establishes a standard and you violate that standard, you have violated your duty. So you're automatically negligent, basically, if that makes sense. So if I get into a car wreck and it's determined that I was driving too fast, I was violating the speed limit, and also the brakes in my car were totally non-existent, they were nothing, there were none left, and I had bald tires, all of those things contributed to the collision, and therefore I was violating safety rules, traffic law, and therefore I've automatically violated my duty. Now again, this is probably the most common duty in a negligence type of a lawsuit, and that's one of the things that a lawyer will do, a plaintiff's lawyer, when you're analyzing a case. The first thing you're going to do is go look to determine, are there statutory rules or administrative rules and regulations that establish the level of duty in this particular type of circumstance. So if I'm analyzing an automobile accident, I'm going to go through, based upon the police reports and other investigation, to determine what laws were not being followed by the person. And they were following too close, they were going too fast, they went through a stop sign or a traffic light, they didn't stop for a crosswalk. Those are all statutory rules, vehicle code, and typically speaking, in almost every collision, there's going to be at least one traffic law that was violated, virtually every time. So that's the first place I'm going to look. If I'm a plaintiff's lawyer, is can I find a law or a regulation or an administrative rule that establishes what is the standard, and then did that person violate it? Again, I used to do a lot of commercial trucking, and I think I showed you the rules earlier in the term. There are literally thousands of rules that commercial truckers have to follow. Everything from hours of service, how long you can drive, how many hours you have to have off in between off duty. In the airline industry, there are thousands of rules on maintenance procedures and all of that. In railroads, virtually every form of transportation. And so that's one of the first things we do in that type of a case involving a semi-truck or whatever, is look to see what safety regulations were violated. And we can usually find a number of them in a case. So basically, this standard, negligence per se, is when there is a duty that's created by law, and breach of that law is essentially automatic negligence. Now, with that said, you still have to prove that the breach of duty was the cause of the injury. So just because if I had a tail light out, which is a violation of a rule, but if that having a tail light out had no connection with the cause of the accident, then even though I violated the rule, it doesn't necessarily mean I'm negligent. You have to show that violating the rule was a direct link with the injury. And we'll talk more about that in a minute. All right, next we have the next type of duty, and this is called the standard of care. And this is the phrase that is used primarily in professional malpractice cases. So medical, dental, law, accounting, other type of professional service activities. This could also apply on farming practices or other type of manufacturing or industrial activity. But typically when we use this phrase, standard of care, the most common place you're going to see this is in a medical malpractice situation. So again, negligence, what is the duty? So if I'm a surgeon and I'm performing surgery, there are standardized procedures for various type of surgeries that I follow, and that will be based upon the technology at the time, what resources I have available as a surgeon. And so essentially, if somebody dies during surgery, I'll probably get sued as the doctor. And then the issue in the case is going to be, as the doctor, was I following the standard of care established in the medical community for that type of a surgery, or that type of a treatment, or that type of a diagnosis? This would also apply to prescribing drugs. What is the standard for, is there an interaction between the drugs I have prescribed? And if I prescribe drugs that have an interaction that's known and published, then I violated the standard of care. And this is where we get into the use of expert witnesses in a lawsuit. So if it's a medical malpractice case, for example, the lawyers will hire expert doctors that basically are witnesses that will analyze the case, review the medical records, review the imaging, review what procedures the surgeon followed, and make a determination that, in their opinion, whether or not the doctor was following the standard of care. And sometimes that's in dispute. And it may vary from place to place as well. If I'm a surgeon at the Mayo Clinic or a large hospital where I have all sorts of resources available to me in terms of equipment and imaging and all of that, the standard is going to be different than if I'm doing surgery out in the middle of Eastern Oregon in a small regional hospital, to a degree, because I don't have a lot of that equipment. So again, it's going to be based on the case and the facts of the case and the circumstances at that time. Now, when we talk about standard of care, there are sort of two components to it. Number one is you must know what the standard of care is. So you have an obligation to keep current on medical technology, on interactions of drugs and pharmacology issues. So you need to know what the standard is. Now, along with that, then, you have to stay current, and that's through continuing education and that sort of thing. So in other words, it's not an excuse to say, well, gosh, I didn't know that the drug pharmaceutical companies have changed the prescription advice for this type of a drug. Well, you should have known. That's part of your standard, part of your duty as a medical professional to keep up on those standards. And if you're not, you're negligent for not keeping up. And then, of course, you must follow the standard once it has been established. All right, so on the test I may ask you, what is the phrase that refers to the level of duty that a professional owes when they're engaged in their professional activity? And that would be called the standard of care. All right, next I put on here real estate, number 4, because this is also an area where we see a lot of cases involving negligence. You know, it's the old slip and fall case, like I go into the grocery store and I slip on a banana peel, or water that's on the floor from in the produce section, you know how they mist everything down, water gets on the floor. So this is the idea that if you are the responsible party for real estate, that is, you're the owner of the property, or you're a property manager, or you're the site facility manager for a factory, or whatever. If you are the one that is in charge of making those decisions, the question is, if somebody gets injured on the property, what is your duty that you owe, if any duty whatsoever, to the injured party? Now this will basically break down into 3 general categories. And the first category is commercial activity on real estate. So a shopping mall, an office building, a public building, whatever. So the idea here is that's going to be the highest level of duty that you owe if you are in charge of that property. And this is called, in either phrase here is acceptable, an invitee. So this is the idea that somebody comes onto your property for a commercial business purpose. You are essentially inviting them onto your property. You're open to the public, so you have the highest standard of care to make sure that they do not get injured. If they come on your property, they're considered an invitee. And what that means then is you have an obligation to be proactive, to go look for problems and fix problems, or take appropriate steps if the problem cannot be fixed, to either close the area down, adequately warn, and that sort of thing. So this is the idea that you need to go out and look for problems. So for example, let's say it's an apartment building, which is a commercial activity. I'm the apartment manager. It's my job to go out and look around for problems, to make sure that the staircase, for example, is not rotted out, to make sure the banister, you know, the grip rail, as you're going up the stairs, is not wobbly and going to fall, or to make sure that the posts holding up the deck on the second floor are not rotted out. Or in a grocery store situation, same thing, you know, to make sure that the water that's come off the produce section has been mopped up. You know, I've got to put down my little, you guys have seen these all over, the yellow warning sign, you know, wet floor, all that kind of thing. Or snow and ice, coming up on wintertime here. You know, if it snows or we have frozen ground, you need to go out and shovel the snow, throw down some de-icer, that sort of thing. So the idea of this is you've got to be proactive. You can't just sit in your office and play Xbox all day. You've got to go out and look for problems. And if somebody gets hurt as a result of a problem that you didn't know about, but you should have known about it, in other words, the reasonable property manager would have found that problem and fixed it, again, back to that reasonable idea, then you're still liable even if you didn't know about it, because you should have found that problem. The average reasonable property manager would have learned of the problem and taken adequate steps to remedy that problem, fix it, or whatever. So this is the idea that you have to be proactive, go out and look for problems, and when you find a problem, take reasonable steps to fix the problem, or otherwise, you know, close down the area or something like that. I'll give you an example. I had this case, this has been years ago, but a lady, she was elderly, she was in a large, well-known department store in the jewelry section. She was looking at jewelry, and at the time they were remodeling the jewelry section. They were putting new flooring in, and they had, you know, the tile floor, the big tiles on it. So they ripped up part of the tiles in one section, and it was just down to the underlayment. And then they still had the old tile And this is going to be a multi-day job. So they shut down for the night, they reopened the next day, and so there was a tile between the tile that was still there and the floor where they removed the tile. There was about a 1/2 to 3/4 inch ridge where the old tile was still there, and they hadn't put new tile down yet. So they did work at night so they could keep the store open during the daytime. So she's there during the daytime looking at the jewelry, and again, she was elderly, she had some mobility issues, and she caught her foot on that little lip. And it was right there at the jewelry case. And her head came down and hit the jewelry case, which is metal and glass, and broke the jewelry case with her head. She had a big old gash on her head, and she was semi-unconscious and went to the ground. So they had no warnings. None of it was cordoned off. They didn't close the jewelry down, for a few days while they're doing that. So what do you think? They settled very quickly, I will tell you that. Yeah, they had an obligation. What I argued, I was representing her. What I argued to them, their insurance company, is you guys shouldn't have had this open, right? Basically, you close it down for a few days, you lose some sales, but you wouldn't have had this problem. And that's what the reasonable average store manager, whatever you want to call it, would have done. And so that's the kind of idea we're talking about. All right, letter B, licensee. So the term licensee in this context refers to somebody that comes onto property at the invitation of the owner, but not for a commercial purpose. So, if I invite you over to watch the World Series or something at my house, and you're there, as my friend, you're not there for a business purpose or anything like that, you're considered a licensee. You're there with my permission, but not for a commercial purpose. So in that case, I have a little bit lower standard of care than you do in a business environment. And that standard is basically, if I'm aware of a condition that could be a problem, like maybe I have my back deck off my house has rotten wood on it, and I haven't got around to fixing it yet. I'm going to do that, this summer when the weather's nicer or whatever. So I have an obligation basically to tell you, number one, hey, don't go out on the back deck. The wood planks are all rotted out. You'll fall through and get hurt. Or, lock it down so you can't get out there. So essentially the idea is I have an obligation to warn of known problems. Now it's still a pretty high standard, but it's less than commercial. And what I mean by that is it's a situation where I know of a problem, I have to warn you about it or take reasonable steps to prohibit access or whatever. But if you're at my place and you get hurt and on a condition I didn't know about, like maybe there was a broken board and I wasn't aware of it and I really had no way of knowing about it, then I could argue, well, I didn't know of that problem, it was a hidden defect, and I don't have the same level of care as you would in a commercial type environment. And so you could argue that because you didn't know about it, you're not responsible. However, nowadays, that's why you have insurance. It's pretty much if somebody gets hurt, insurance is going to basically cover it. So a little bit lower standard. All right, then we get down to letter C. Letter C refers to somebody that is on your property without legal right to be there. They are trespassing on your property. And they get hurt when they're trespassing. And then they sue you. So basically they come into your backyard, they have no right to be there. They put their foot into a hole that you have in your yard from when your dog dug up the hole in your yard that you didn't fill back in, and they break their leg. So they're trespassing, they get hurt, and they sue you. You're like, wait a minute, you're not supposed to even be on my property, let alone turn around and sue me for it. So historically the idea was if somebody is not lawfully on your property, you have no obligation to them whatsoever. If they got hurt, too bad, they couldn't sue you because they weren't legally, rightfully there to begin with. And that makes sense to a degree. Now, this has kind of changed over the years, and part of this has to do with situations involving children, and the idea that if you have a property that has some sort of what's called an attractive nuisance, like a swimming pool or potentially a trampoline or a hot tub or something like that, and it's likely that children will come onto the property to use it, even if they're not supposed to be there, then you still have an obligation to take reasonable steps to prohibit access. And now, most of the time, this is also going to be set forth in building code. So if you have an in-ground pool, for example, most states will require a fence around the pool area that is lockable. Depending on the state, it may be a 4-foot fence or up to a 6-foot fence or maybe even 8 feet, so that you can lock it down. That way children can't get on the property and go in the pool, or at least, you know, it's a deterrence. Or another situation is, I had a case once involving an empty lot that was next to a convenience store and a school. And the children would cut across the lot at lunchtime to go to the convenience store, and you know, they're trespassing, but there was a trail that had been there literally for 25 years. I mean, it was a daily occurrence. And of course what happened, a student was going on there, fell down because of a big pothole out there, broke their leg, and they sued the landowner. So and the idea was, well, the landowner was well aware of it, didn't take any steps to make sure there was no potholes or whatever. That case got settled, but you know, it's kind of a dubious one in my opinion. So the other duty is to not willfully injure. So this is basically what I call the booby trap duty. That you have an obligation not to do things that establish something where somebody is going to get hurt by coming on your property. So I can't put like broken glass all through my lawn to keep the kids off my lawn. Or I can't, you know, set up a weapon that's pointed at the door when I go on vacation that has a little string, so if somebody opens the door, it shoots them. Those kind of things. I can't set up a trap to willfully injure someone. That would be a violation. All right, so for you guys, I want you to be able to list out 4 of these, and I will consider each of these real estate ones as separate. And I will accept different words, invitee or commercial or business purpose, or any description like that is a fine answer. By the way, on the fill in the blank questions, if you can't remember the exact term, you know, write something kind of describing it, and if you're hitting the right points, I'll give you credit for that. So if you can't remember the exact word, say, okay, I can't remember invitee, but somebody's on there for a business reason. That's the same thing. So if you describe it well enough, you'll be fine. All right, so how does that play out? Back to our 4 elements. So duty, breach of duty. So what is the duty? That's the first thing. What is the level of responsibility that was owed? Was that person following or up to that level of care, that standard? So duty, breach of duty. Now, again, you must have all 4 of these elements. So let me give you an example. Let's say I'm driving down the road in a 35-mile-an-hour speed zone and I'm going 80 miles an hour. Am I negligent? All right, so what's my duty? Go the speed limit, 35. I'm going 80 miles an hour. Am I negligent? Remember what you have to have. Right, shaking your head up there. All 4 elements. What's my duty? Drive the speed limit. Am I breaching that duty? Absolutely. But what's the problem? Why don't we have negligence? Yeah, there's no injury yet, right? Nothing happened. I was going too fast. Might get pulled over for speeding. That'd be a heck of a ticket too. But I didn't cause an injury. Duty, breach of duty, and an injury that's caused by that breach of duty. Got to have all 4. I mean, we violate duties all day long. I venture to say that driving here this morning, I probably breached a duty. I went like 26 miles an hour in a 25 zone, right? Ooh. But I didn't cause an injury. So the old saying, no harm, no foul kind of thing, right? That's what we're talking about here. And this also plays out too. I do this in my own law practice. Maybe I'll spell somebody's name wrong on a will or something, on the draft copy. Or I may get a legal description wrong on a deed. Happens all the time. But I fix it before it becomes a problem. So there's not been yes, I violated my duty to get the legal description correct, but I fixed it before it became a problem. So again, that's why I really highlight all four of these elements must work together. So when you're analyzing a negligence case, duty, was the duty breached? What is the injury, and was that a result of the breach of duty? All right, so when I talk about injury, I have here PI and PD. PI stands for personal or physical injury. PD stands for property damage. When I use the term injury in these four elements, I'm not only limiting it to a physical injury that you have caused. It means both a physical injury, property damage like to your car in an automobile accident, and it could also be loss of value to the car, diminished value, not just the repair costs, but the reduction in value as a result that your vehicle now is in an accident and it no longer would be worth as much as a vehicle that had not been in a collision. So it's both physical injury, property damage, or any other type of harm that you may have had as a result. So maybe somebody was negligent in a way that it caused you to lose profits in your business. Maybe there was a fire next door, and that fire in a building next door to your office, the smoke came over and caused your office to be shut down and have to be all cleaned up and all of that. And so you lost out on maybe a month of activity in your business because of that fire. So you would sue for lost profits, cleanup costs, and that kind of thing. So the point I'm making is, when I use the term injury, I mean that in a very broad way. Physical, property damage, lost profit, damage to reputation, diminished value, whatever you can prove was a direct result of that breach of duty in a very broad scope. All right. Next we get to this term causation. All right. Causation. What do we mean by that? We mean that the breach of duty, the injury, that there was a link between what you did wrong and the harm that occurred. There must be established a link between those two. If there is no link, then even though you have an injury, even though you have a breach of duty, there's no negligence because you don't have all four elements working together. Now that sounds so simple, but in the reality it's not that simple. And this is where you get into situations where, how far down the line do you go in proving somebody's responsible? So let me give you kind of a goofy example. But, I forgot, before we get there. So there are two components to the idea of causation. Number one, actual or factually linked. Was what you did wrong a substantial factor in the injury that resulted? Is there an actual factual link? Part two is how remote or how foreseeable was the injury from what you did wrong? There are two components to that. So let me give you an example and I'll sort of illustrate what I'm talking about. All right, so let's say this is Interstate 5. Here I am in my car. I'm going down I-5. oh, I'm thinking, okay, kind of down by Eugene, say I'm on the way down to watch a football game, and I'm flying. I'm going 125 miles an hour, right? Down I-5. So, over here, this is an apple tree. And so let's say here we have the owner of the property is up on a ladder picking apples. The owner falls off the ladder and gets hurt. And then sues me for negligence. I'm driving by somebody picking apples on a ladder, right next to I-5, right? Their house is right up against I-5. So I'm going down I-5, 125 miles an hour, eating a cheeseburger, playing with my radio, talking on the phone, adjusting my tie. I'm all kinds of breach of duties, left and right? And somebody gets hurt. So we have breach of duty, and we have injury. What's the problem? Causation. What did my speeding have to do with that? Right? You're like, what? That doesn't have anything to do with it whatsoever. All right, well, let's talk about that a little more. So let's say the property owner here has lived there, let's say 30 years. And over the course of 30 years, they are used to the traffic. They don't even hear or notice the cars going by. It's kind of like living next to a railroad where after a while you just don't even hardly notice. And so in this particular case, the person that got hurt says, I'm used to it. I've lived there for 30 years. I'm used to vehicles going fast down I-5. It happens all the time. But on this particular day, Hasbrook going 125 miles an hour was flying. And I was up on my ladder picking and I went, whoa, look at that car going so fast. And as a result of that, I lost my balance and fell off the ladder and got injured. Had Hasbrook not been going that fast, I would not have done that. I would not have fallen off the ladder. So now, is there a link, factually speaking? If I would have been going slower, or but for, right here, whoops, but for my going fast, the person would not have fallen off the ladder. So my excessive speed was a factor on a factual level. There is a link between what I did wrong and the person getting hurt. So we do have causation, don't we? You're going, that doesn't seem right though. Why? Here's why. That's why we have the second part to causation. Not only do you have to show there is an actual factual link to something, but you also have to show that the injury that resulted is a foreseeable type of injury for that breach of duty. And again, this goes back to reasonable person. Would the reasonable person, when they're breaching a duty, foresee that somebody might fall off an apple ladder and get hurt? Is that the foreseeable type of injury? Not really. Now, if I would have gone off the road and actually hit them, for sure. Or if I ran into somebody when I was changing lanes going that fast or something else, or maybe a bicycle rider on the road and I'm going so fast that it causes a big air cushion and knocks them off their bike. That kind of thing is foreseeable. But we would argue in this case that it's not really foreseeable that somebody off the road far enough that's not impacted in any physical way, it's not really foreseeable that somebody might fall off a ladder when I'm driving that fast. Now, would I still get a ticket for reckless driving? Oh yeah, but that's a different thing. So this is what we call proximate cause. The reason why we say proximate, proximity, how close is something? How close is the injury from the bad action? And if it's too far removed, too far away, not close enough, then as a matter of law, we would say even though there was a factual link, albeit very tenuous, it's too far away to be a foreseeable type of injury. And therefore, as a matter of law, you're not liable because it's not foreseeable. Or another way of saying it, it's too speculative. And of course, the other arguments you can make is the ladder was wobbly and they slipped and all that too. So this is where a lot of times we get into arguments in court. It's not necessarily over a breach of duty. That's usually pretty obvious. But the question is, was the breach of duty, is there a causation issue? Now there's another issue when it comes to causation. And that involves our defenses. So let's talk about those for a moment. Defenses to negligence. So when I talk about a defense, I'm talking about an argument that would be made in court by the lawyer for the person that's accused of being negligent. And the idea is there an argument that the person, number one, was not negligent whatsoever and doesn't have to pay anything, or maybe they were partially negligent, but there were other contributing factors that need to be factored in on a percentage basis. So the first type of a defense in a negligence case is that, number one, all four elements don't really line up with each other. And so if you can show there's no causation at all, or there was no breach of duty, then there's no negligence. So that's sort of the underlying best defense. You weren't even negligent whatsoever. But these are some of the other defenses that are commonly argued. So the first two are very similar to each other, but they have vastly different outcomes. Contributory fault, or otherwise known as contributory negligence. Comparative fault. All right, so this is the idea that somebody gets hurt, their injury is caused by another person, but the person that was hurt also did something that led to the event that caused the injury. In other words, they're partially at fault for their own injury. Maybe not 100%, but some percentage of fault for what they also did wrong. Or the person that was injured was doing something wrong that didn't really lead to the accident, but made their injuries worse than they otherwise would have been. So in other words, they contributed to their own injury. Now this is a really common thing. In almost every automobile accident, if you will, collision, you've got a primary person at fault, and oftentimes the person that was injured also was doing something wrong. Maybe they were falling too close or whatever. So this is where we get into the idea of percentages. So like, let's say for example, here I am in this car. I'm stopped at a stoplight, waiting for it to turn green. Minding my own business. You come up behind me and you don't notice that the light's red. You don't see that I'm stopped there. You're speeding, like I say, eating a cheeseburger, playing through radio, talking on the phone. You're just not paying attention whatsoever. So you run into me. I'm there minding my own business, watching the light, waiting for it to turn green. All of a sudden, boom, you run into me. And as a result of that, you're going so fast that I go through the windshield. I land on my head and my neck gets broken. Horrible, horrible situation. So you're the one at fault. You ran into me. Plus, the reason you ran into me, we were doing all kinds of bad things, not paying attention just at the very minimum. So, of course, I'm going to sue you. Now, when I sue you, your lawyer is going to raise a defense that I also was doing something that was wrong. What am I talking about? Correct. I was not wearing my seatbelt. You're like, well, wait a minute. That didn't, me not wearing a seatbelt didn't cause you to run into me. You ran into me. It doesn't matter if I was wearing my seatbelt or not. You would have run into me either way. That's the argument I would make back. And then the argument that would be made back to that is, well, had you been wearing your seatbelt, you would not have gone through the windshield. Yes, you would have still been injured. That's not the issue. But if you would have been wearing your seatbelt, your injuries probably would have been, some broken ribs from the seatbelt, maybe whiplash type injury. The airbags would have deployed and, helped you out. But because you went through the windshield, by not wearing your seatbelt, you made your injury worse than it otherwise would have been. That's the argument that they would make. And so this is where we get into this idea of percentages of fault. This is a question for the jury and also for the judge. So how does that play out? So that leads us to these two different rules. And I put over here old rule, new rule, so to speak. The old rule, and this goes back to Old English common law once again. The old rule was basically the idea that if you can show that the person that is hurt was even 1% at fault for their own injury or level of injury, then they couldn't sue at all. They got nothing, no matter what. And so even though